I'm very sorry that I can't be with you this morning in person to pay my respects to President Ma and to Minister Lin, to University President Pan, and to Law School Professor Jung. I'm also very sorry that I can't participate in person with so many well-known authoritative colleagues in the field of international law and the law of the sea. But I am grateful for the opportunity the hosts have made for me to take part via video. And I'm glad to discuss this problem because I fear that it's going to become a crisis unless dramatic steps are taken by all concerned to meet the challenge. 50 years ago, I started to study China and international law with the enormous cooperation of the late Professor Cho Hong-da. It was a bad time to begin. China was on the verge of the great proletarian cultural revolution. During that period, it committed very many violations of public international law, especially with respect to diplomatic immunities. And it looked like China might be ready to make good on the threats it had periodically made since the establishment of the People's Republic in 1949 to overturn the international community's rule-based system. The United States was also facing a very important turning point. The question for us vis-a-vis China was, would the United States improve its attitudes and policies toward China in the world community? Would it finally establish diplomatic relations with the People's Republic? Would it stop trying to exclude the PRC from the United Nations? Would it cease its actions that were interfering with the conduct of the PRC government and cease its espionage and other unfortunate activities? There were many questions for the United States, which at that time was really prohibiting all trade with China. Not a happy way to conduct international relations. So both sides in 1966-67 had to reconsider their policies toward each other and toward international law. Today, 50 years later, the circumstances in each country are very, very different. Yet once again, we're at a point where both China and the United States have to reconsider their views of international law, and especially with respect to the South China Sea, as well as the East China Sea. China has to consider its views toward the forthcoming decision of the Law of the Sea Arbitration Tribunal that will decide the dispute brought by the Philippines to the tribunal against China. If Beijing rejects that decision, as it now appears determined to do, it's going to be very unfortunate for the PRC. It will damage its efforts to attain soft power in the world more than a mere ignoring of the decision might be. We don't know what Beijing is likely to do. It can't be good for the international system. We already recently have had the example of Russia in the Arctic Sunrise case, thumbing its nose at the tribunal, although in practice, over a period of 8 months, it actually complied with the UNCLOS Arbitration Tribunal's decision without recognizing it. The Philippine arbitration also highlights the challenge for the United States. Although the United States claims to abide by and appears to abide by the UNCLOS Convention in most respects, it has failed to ratify the convention. And this is a very sorry situation where, in effect, the U.S. is telling other parties, including China, do as I say, not as I do. Right now, our refusal to ratify UNCLOS and President Obama's evident decision that it would be worthless to try to persuade the Senate to grant its ratification so many decades after the United States signed the convention, puts us in a very awkward situation. It makes it look like we are relying on military gestures, our own sorts of implicit threats, to meet the Chinese assertions and assertive conduct in the South China Sea. Now, despite America's ambivalence toward UNCLOS, in theory and in practice, I think it's time for China to reconsider its rejection of the forthcoming arbitration tribunal's award. We don't know, of course, what the Chinese will do when push comes to shove. But so far, it looks like politics is in command in this respect, as in so many others in China. Of course, sophisticated observers in the United States, and perhaps in Taiwan too, are familiar with examples where political considerations have been deemed more important than international legal considerations to national decision makers. Right now, Xi Jinping's dictatorial regime has such a repressive atmosphere that it takes an act of courage for any official within the government to differ from the current PRC posture of rejecting the arbitration tribunal's award despite China's commitment under UNCLOS to honor this method of dispute resolution. There are many options, of course, that China can consider. We shouldn't believe that the Chinese posture toward international law under the communist regime is written in stone. We have a number of examples where, over time, the leadership has changed its position. And I think we have to act in a way to encourage it to reconsider its position with respect to the Philippine arbitration. So far, the PRC has persisted in its view that third-party determination of important international disputes is not acceptable. They have been rejecting the possibility that arbitration in law of the sea matters can actually promote negotiation by clarifying some of the basic issues and stimulating negotiations that for many years have otherwise been going nowhere. In 2012, October, I published an article advocating that all the nations of East Asia adopt arbitration or adjudication as means of settling their maritime and territorial disputes. Some people who have more experience than I in international relations said it's totally unrealistic. Nevertheless, the next month, the then Japanese foreign minister in the government that was about to yield to the new government of Prime Minister Abe published an article in the International Herald Tribune in which he said that Japan would be willing for China to take it to the International Court of Justice to settle their bitter dispute over the Diaoyu Senkaku Islands. I took some heart from that, especially when I learned that legal experts within the Gaimusho, the Japanese Foreign Ministry, took the same position. But the new government of Prime Minister Abe has not been willing in public to explicitly reinforce that posture, although lately we've seen some hints that that position in the East China Sea might be weakening. It took the Philippines' stunning decision to bring the case against China under UNCLOS in January 2013 to bring what had been a somewhat theoretical discussion that had been called in some quarters unrealistic into the real world. I was very excited when I read the beautifully constructed Philippine notification to the arbitration tribunal. China's response, unfortunately, as you know, has been very disappointing, not only questioning the tribunal's jurisdiction, but also its right, of course, to deal with the merits. Most discouraging is not the Chinese opposition, but the refusal to submit their claims, their response, to the tribunal for an impartial decision by some of the world's leading experts on the law of the sea. China even seemed to be taking the position that third-party determination, whether it be arbitration or adjudication, really was no longer a peaceful means of settling disputes, despite the fact that it's obviously been authorized in Article 33 of the UN Charter. That was a claim that the preliminary decision of the Philippine Arbitration Tribunal has persuasively already disposed of. So what are the PRC's choices as it confronts the impending award? One is to say nothing, but continue its process of ignoring everybody else also and paving over various submerged features and low tide elevations and mere rocks and converting them into artificial islands with airfields and ports and other facilities that evidently have military capacity. At the other end of the spectrum, the PRC can angrily denounce the UNCLOS treaty in protest and withdraw from the system. That would be an extreme reaction and an extremely unfortunate one that would hurt the PRC's reputation more than merely thumbing its nose at the arbitration award. It would also deny China the chance to continue to participate in the interpretation and application of UNCLOS with respect to many other important features of the treaty. So I don't think that's likely. What seems most likely, and we've already seen considerable evidence of it, is that the PRC and its spokesman, and unfortunately some of its scholars, will continue to disparage the tribunal itself, challenging the way the tribunal was constituted, claiming that these world-famous experts are really not independent, perhaps not even sufficiently able, certainly not impartial in terms of handling this particular dispute. It's an ironic and especially unfortunate charge for the PRC, since it could have participated in the construction of the tribunal and the selection of the arbitrators, but it chose not to do so. What the PRC obviously should do is to accept the award by the tribunal, whatever it decides, and then go back to the negotiating table with the Philippines on the basis of the various issues clarified by the award. That would be a constructive approach, and the PRC wouldn't have to mention the award. It wouldn't have to lose face. Philippines wouldn't have to rub the PRC's nose in any issues that it's lost. And this is not really a hopeless prospect. Ironically, Prime Minister Modi of India, in the summer of 2014, when he inherited India's arbitration dispute with Bangladesh over the Bay of Bengal, having lost most of the case, he accepted the decision. He's supposed to be a very nationalistic leader. He could have done what Vietnam did to Chinese, even people from Taiwan, when China sent its oil rig into disputed waters off Vietnam. But Modi didn't order any riots. He said it would have been better if we had won the case, of course. But the great thing is the decision has put to rest an issue that has plagued our relations for decades. And now we can go on and cooperate with Bangladesh on the basis of the decision. Now, that was a remarkable statement for a supposedly nationalistic leader, and it constitutes a very good precedent for the leaders of China and of any government that doesn't fare well in an arbitration. There are many possibilities for the PRC to respond in negotiations. Horse trading is very, very possible with respect to the territorial claims between the parties, the maritime limitations, the maritime entitlements at issue, and other matters, if the parties are willing to sit down and horse trade. International law offers many decisions and the examples of many successful negotiations for precedents that could stimulate good faith negotiation. What diplomats don't seem sufficiently to appreciate is that's why we have these international institutions. It's not good enough for parties simply to say, oh, we're right under international law and the other people are wrong. We have impartial institutions available, as the Philippines demonstrated, to try to clarify matters and promote negotiations. Now, of course, the problems of the South China Sea, as people in Taiwan know full well, are not just bilateral questions. They involve many other players other than China and the Philippines, and foremost in this respect is Taiwan. And the situation of Taiwan is very, very delicate. On the one hand, you have a new administration coming to power very shortly, and despite its mistrust of the PRC, President-elect Tsai Ing-wen's group is unlikely to abandon the claims that the ROC has made to the South China Sea under the banner of China. On the other hand, the ROC has really been eager to eliminate the barriers to its formal participation in the world community, and has been very careful, especially of late, to portray itself as a loyal supporter of the UNCLOS system, even though it's barred from the UNCLOS system to date. Taiwan has not endorsed, at least lately, the vague interpretations of the notorious 9-dash line invoked by Beijing, nor has Taiwan defended Beijing's creation of these artificial islands capable of military use. The Philippines arbitration has really demonstrated the cruel dilemma confronting Taiwan, as well as some differences in the legal positions of Taiwan and mainland China. While Beijing has rejected the arbitration, Taiwan has been eager to take part. The tribunal, of course, may not only rule on the validity of the U-shaped 9-dash line, but it may also render an authoritative interpretation of the ambiguous Article 121.3 of UNCLOS, and that will answer the very important question of greatest interest to Taiwan, whether Itu Aba, Taiping Dao, is entitled to a 200 nautical mile exclusive economic zone. So Taiwan is frustrated, understandably. It's precluded from becoming a party to the arbitration and stating its case. It was even denied the status of observer at the arbitration, as several states were granted. And apparently, at least formally, the very good memorandum prepared by the China-Taiwan International, the Society of International Law, the Chinese-Taiwan Society of International Law, an influential non-governmental organization here in Taiwan. The brief they've submitted has not formally been accepted, although fortunately it's part of the public record and should be considered, I think will be, by the arbitrators in the Philippine case. So in these circumstances, the ROC understandably doesn't want to accept the tribunal's decision as binding upon it. Yet it does not want to put itself in the unattractive PRC position of rejecting an authoritative decision of the UNCLOS system. Now, how Taiwan actually chooses to cope with the arbitration decision will obviously depend in large part on what that decision is. A favorable interpretation of Article 121.3, for example, may produce grateful acquiescence by the ROC, if not explicit reliance on the tribunal's views. I hope that the other major players in the South China Sea will follow the Philippine example. There is no barrier to Vietnam, Indonesia, Malaysia, all bringing arbitrations that could follow up the Philippine decision. Each arbitration could invoke as arbitrators 5 different specialists, all of whom are well known and very qualified. And their decisions could have the effect of backing up the power and legitimacy of the Philippine arbitrator's decision. If that's done, it would be increasingly difficult for the PRC to say that its position on lack of jurisdiction and on the merits of its dispute with the Philippines and other littoral states are correct. So I'm in favor of bombarding the headquarters, as they used to say during the Cultural Revolution, with not missiles, but complaints, legal petitions, seeking legal determinations of the controversial issues involved. Even Japan might well be able to not only take the East China Sea questions to arbitration and adjudication, but also take advantage of its membership in the UNCLOS system and its major interest in freedom of navigation in the South China Sea to fashion a complaint against China that would bring into question, for example, the legitimacy of the 9-dash line. A lot can be done if the parties see the possibilities and importance of public international law and its institutions that provide so many precedents and good examples for settling these very dangerous disputes. And I think it's time for both the United States and China to again reconsider their positions with respect to public international law. The United States and China, in their different ways, should now both act to strengthen, not to weaken, UNCLOS and the international system that has been so painfully and carefully erected to preserve world peace, because world peace may be at stake. We want to avert a kind of high noon, dangerous incident that is now appearing to confront us, even this week, as we consider the Scarborough Shoal and the dangers involved in the threats being made by the parties. Well, I look forward to the discussion and to the statements of other specialists in this area. I'm sure this will be a very important and successful conference. Thank you for your attention.